Robert Jenrick has now crossed a moral Rubicon, be in no doubt. His defence of Hamid Joshkun's Qur'an burning may appear on the surface a principled defence of free speech, but in truth it's an act of political theatre designed to recast himself as a martyr for liberty while playing to the populist undercurrents that have come to dominate the conservative right. After the Birmingham White Faces debacle, Jenrick is not rediscovering moderation, he is radicalising further, cloaking his extremism in the garb of liberal principle. And the distinction between what is legal and what is right is essential here. The appeal court was not applauding Qur'an burning as an honourable form of discourse. It merely reaffirmed a narrow and necessary legal principle that offensive speech, however crude, does not automatically constitute a crime. And the judge, Mr. Justice Benathan, made this explicit, that the law protects expression even when it shocks, and that offence alone cannot define illegality. The ruling is jurisprudence, not moral endorsement. Jenrick, however, treats it as vindication of his worldview, as though defending the right to burn a holy book were tantamount to defending the Enlightenment itself. It is deeply cynical. The law upholds the right to offend. It doesn't sanctify the act of doing so. A liberal democracy tolerates the ugly precisely because it need not glorify it. Yet Jenrick's rhetoric collapses this nuance. By presenting Joshkun's provocation as a triumph of free expression, he is normalising the politics of antagonism, the idea that democracy thrives not on debate but on deliberate provocation. And this is the Trumpian impulse, to turn freedom into spectacle, outrage into virtue. And in this sense, his pivot back to real life is not a rehabilitation but a continuation of his descent into the populist abyss. There's also something grotesque in his attempt to cast the Crown Prosecution Service as would-be inquisitors recreating blasphemy laws by the back door. Britain abolished those laws because faith and conscience cannot be policed, but the public order framework exists to protect people from hatred and harm, not to shield ideas from criticism. When a man burns a Qur'an outside a consulate shouting Islam is a religion of terrorism, this is not an abstract criticism. It is a calculated provocation against a community, and the court has said this is not criminal. It didn't say it was right. And Jenrick knows the difference, but he no longer cares. His strategy now depends on the performance of defiance against courts, civil servants, and the very constitutional moderation he once embodied. In his hands, free speech becomes a bludgeon rather than a principle, and the irony is stark. The self-styled defender of liberty now advances a politics that thrives on division and fear. The real legacy of his case, or of this case, should have been a sober reaffirmation of the law's restraint, that Britain can protect both expression and civility without collapsing into censorship or hatred. Instead, Jenrick has transformed it into a morality play of his own making, one in which he stands as the new apostle of freedom, while in truth he marches into deeper, ever deeper, into the shadow of the populist right.